Good morning, I'm Father X. In this episode, we'll talk about preparing your testimony about the best interests of your child for your custody trial. I'm teaching you the topics that a judge is required to consider in determining custody of your child. And if they ignore these facts and still rubber stamp the mother for custody, then you stand a better chance of winning an appeal, as I discussed in episode 10. The normal routine in court is the way for dads to lose, and I'm teaching you the way to win, the way I did it to save my son. In this episode, we'll talk about 4 best interest factors: the home environment, the availability to parent, the parent's financial stability, and the siblings. As you testify about these topics, remember the goal is not to angrily show that the mother is evil or incompetent. And the goal is not to be super critical about minor things the mother does wrong. The goal is to confidently show what the actual facts are and what's actually in the best interests of your children, and separate that from the best interests of the mother or the father. You cannot assume that any family court judge has the intelligence to figure out what's best for your child. You're the one who has to figure this out and tell the judge. Let's get to it. First, the home environment. The home environment factor relates to the physical home environment. It can also relate to any domestic violence or psychological risks the child is exposed to in the home. But if these types of safety or psychological issues exist, you can discuss it under those best interest factors. Your goal here is to prove that your physical home is appropriate for your child and for your child's age. This is easy in most cases because most people have normal homes. Even though it's easy, you still want to show your home is adequate because you want to block the judge from concluding, "We don't know anything about the father's home. I can't give him custody because I don't know how the child will live." So you want to discuss basic topics such as, if your child is a toddler, are the electric sockets plugged in and covered? Did you baby-proof the house? Do the windows have safety guards? Are there gates blocking the kids from the stairs? If Child Protective Services goes to your house, they'll focus on these basic things. If your child is still a baby, do you have all the appropriate furniture and items she needs, like diapers, food, baby bottles, baby toys, pacifiers, a crib, a car seat, a thermometer, etc.? If you don't know everything that your child needs, just go to the children's section of a major store like Target or Walmart. Walk through the aisles to see everything they have on their shelves, to understand all the items a child might need. Spend 2 hours looking at all the products, and you'll become an expert. I did that myself when my son was born. Go tomorrow if you must. Don't wait. It also helps if you're the one who shops for your child's needs. Hopefully, you did that during the relationship. But if not, then start now. It's not something you should outsource to the mom, because primary custodial parents handle this stuff for their child. If you want the job, then do the job. And then you can testify that you already do the job, not that you will do it later. If your child is school-aged, does your kid have their own bedroom or bathroom? Does your child's bedroom have a door so they can have some privacy and independence? Compare the parents' homes, especially if one of them isn't adequate. Who else lives in each home? Do they provide a risk or benefit to the child? How? Is it a dangerous new boyfriend? Or is it a grandparent that helps care for your child? Are you in a safe neighborhood? Compare both parents' neighborhoods if this is a real issue. If your physical home environment has what your child needs to live in it, then this is an easy factor to prove. Your goal is just to show your home is adequate, so the judge knows that if the child lives with you, they'll be in a decent home. The second topic is availability of parents. The goal here is to demonstrate you have the time available to actually parent your child if you're the primary custodial parent. If your child is under 5 years old and not yet going to school, they need to be taken care of all day. Are you available to do that, or are you working? If you're working, do you have a babysitter available? Is the babysitter good? If you have an irresponsible babysitter, that's a reflection of your parenting, so make sure you get one that's reasonably competent, because they're taking care of your child. If you have alternate weekends now, and you don't have parenting time while you're working, but you want 50-50 or primary custody, then it means you're also asking for parenting time on days you're working. Therefore, during the trial process, you should already be looking for babysitters. You'll want to testify that you've interviewed several babysitters and you have them ready to go when you get custody during your work days. You must be proactive because if you want the job of a parent, then you have to show you already know how to do the job. If your child's in school, that's from about 8 a.m. until 3 p.m., depending on the school. What arrangements do you have from the end of the school day until you get home from work at 6 p.m.? And when you get home from work, is your schedule open for parenting, or do you have other commitments? Remember that your primary goal is to raise your child, so demonstrate that you don't have any commitments more important than parenting. There are some cases where the father travels a lot for work and isn't even available to raise their child during work days. That's a big hurdle to overcome because you're not even available to parent. In cases like this, the mother would have to be so unfit to parent that her raising the child during work days is a worse option compared to you hiring a babysitter to raise the kid while you're out of town for work. It may be hard to prove, but if that's your situation, then that's the case you have to prove. Here's some questions you can answer to demonstrate your availability to parent. What's your child's typical daily schedule on school days and weekends? How available are you to be at home with your kids before school, after school, and on weekends? Who cares for your child when you're not at home? Do you have a stable babysitter, or do you struggle to find a babysitter every time you need one? Does your work schedule impact your ability to care for your children when they're not in school? Be specific about actual times. Does the other parent's work schedule prevent them from caring for the child? It's much better when you can say your work schedule already allows you to be the primary custodial parent, as opposed to saying that if you get primary custody, then you'll change your work schedule. A judge might not believe that you'll actually be able to change your work schedule. Prove that you can. The third topic is financial stability and the ability to provide for the child. The goal here is to demonstrate you have the financial resources to raise your child. If we do the math, I think we find that generally it costs around $5,000 to $12,000 a year for your child's basic needs, depending on their age and activities. And on top of that, consider the cost of their medical insurance and babysitting costs. So your goal is to show you have a stable job and income to support your child as the primary custodial parent. The tricky part is that if you're employed, that's good, but it means you're not completely available, which is bad. And if you're unemployed, that's bad, but you're more available, which is good. But within this matrix, there are countless different scenarios. Is it better for your child to live with and learn work ethic from the working parent versus the unemployed parent? Also, a parent being unemployed and available for 7 hours from 8 a.m. to 3 p.m. isn't worth much when the child is in school. Daytime availability matters for toddlers, but matters much less for kids from ages 5 to 18. If the mother is unemployed or on welfare, courts make the working father pay child support to sustain her household. The courts often justify giving custody to the mother, even though she can't afford to raise the child, by pretending that child support will make her financially capable of raising the child. However, this court logic is often wrong, because even with child support, a child living with a father who earns $95,000 a year will have a higher standard of living compared to staying with a mother earning $25,000 plus child support. Do the math for your specific case. I have to warn you about a risk on this topic. Understandably, many judges would see it as cruel to deny a parent primary custody based on income, because it penalizes them for being poor. It's kind of crazy to tell a parent that they can't be the primary custodial parent because they don't make enough money. But the law and court of appeals say that financial stability and the ability to provide for a child is a factor in custody decisions. When deciding between two parents, the focus must be on the child's best interests, not empathy for the mother. Also, financial stability is just one of many factors, and custody doesn't automatically go to the wealthier parent if they're unfit based on the other factors we've discussed. So when discussing financials, simply state that you're better able to provide for your child and move on, without trying to make the mom look bad. The family court system, which is mostly women, has excess sympathy for mothers. Judges may sympathize with a mother struggling to support herself. Remember that the judge likely cares more about the best interests of the mother than the best interests of the child. A judge might look at you as a monster if you say you should have custody just because you make more money. Be careful. Emphasize that the goal is your child's best interests, not punishing the mother or prioritizing the higher earning parent. Don't let the narrative become about taking the child from a struggling mother. Instead, the focus is on providing the best environment for your child, given that your kid has options to live with either one of two separate parents that have equal rights. Here are some questions you can ask to determine each parent's financial stability and ability to provide for their child. What's your annual income and your ex-spouse's income? Describe your job and income stability. What's the mother's job stability? Do you tend to keep your job for many years, or do you cycle through jobs every year? Does either parent go through long periods of unemployment or job instability? How much does it cost exactly to raise your child for a year? Can you afford that? Can your ex-spouse afford it? If custody and child support is awarded to the other parent, would that household income with child support be as high as yours, taking out child support from your income? Would the child be better off financially if he just lived with you most of the time? The fourth topic is siblings, brothers and sisters. Generally, courts prefer to keep all the siblings together, but this doesn't always have to be the case. For example, if the kids are far apart in age and one child is 16 years old but the other is 5 years old, maybe that justifies each child living with a different parent. Ask yourself, if there are any siblings, is it better to keep them together, or is it better to split the siblings between two homes? Talk about the impact on your child if they end up living apart from their siblings. If there's a negative impact, how will you address that if you each have primary custody of one or more of the kids? Also, because the courts usually prefer to keep the siblings together, the opinion of an older child might determine custody for all the children. Remember that the preferences of the child matters a lot more if they're teenagers. Assume your children are 16, 12, and 10 years old. The 16-year-old gets more input to decide where they live. If the 16-year-old decides to live with you, and the courts agree, then to keep the siblings together, it means the 12 and 10-year-old children will also live with you. So if the oldest teenage child wants to live with you, that's a good sign that you'll get custody of all the children. But it depends on the total circumstances and your facts. Also, this gets complicated if there are stepbrothers or half-sisters. For example, what if you and your ex have a 7-year-old child who is the topic of this custody case? But she has remarried and now has a 1-year-old child with her new husband. Or maybe her new husband has his own 5-year-old child in their home. Whether or not the court separates those children depends on your child's relationship with these other kids. Is your 7-year-old child better off living with you versus living in the mother's home with stepbrothers and half-sisters? It depends on the facts. For example, if you can prove the mother is unfit to raise your child, then it doesn't make it better for your child to live with her if there are other stepbrothers or half-sisters in that home to share the craziness. It's better to save your child from crazy and just let the other stepchildren deal with the mother's craziness on their own. We're not litigating about those other children. So now we've covered 4 more best interest factors. In the next episodes, we'll discuss more best interest factors so you can learn what to talk about and how to put it together for your judge. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.